All right, Melissa Paez. Norma, on this case, it's set for sentencing. State, this is Melissa Paez. It's set for sentencing, but defense counsel is out of county on another matter. So is everyone okay? It's an opposed offer. I don't know. Did you all have witnesses?
If we're not opposed to it, if you were exactly what it is.
Okay. All right. So we won't be able to do it on Friday because I have a mental health docket.
Okay.
So if you can speak with Miss Ferguson and you all come up with a date. So we're just trying to get a date for your attorney to be here, okay? So if you'll confer with her and then let me know what date y'all have decided on.
Yes, ma'am. All right. Thank you, Judge.
Thank you. Jamison Franklin.
Your former. It used to be my guy. He upgraded, I see. Can I have one more?
Court is calling 2025 CR 004-587 State versus Jamison Franklin. Could I have parties announced?
And Jonathan Alvarado for the defense.
And are you Mr. Franklin?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision with your attorney? And did you understand it?
Okay. So, Judge, I apologize. I have not gone over the First Amendment with him. Just kind of show it to it real quick.
Okay. All right. So, Mr. Franklin, did you have a chance to review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney?
Yes, yes,
And did you understand it?
yes.
Are you the same Jamison Franklin who was placed on community supervision for the offense of manufacturing delivery of a controlled substance penalty group 1, 4 to 200 grams on July 24th, 2025 for a term of 8 years? Is that you?
Yes.
All right, state.
On state's first amended violated condition number 1 on or about the 3rd day of December 2025 in Bear County, Texas, the defendant Jamison Robert Franklin committed the offense of possession of controlled substance or violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated.
Well, I mean, if he's pleading not true, today is supposed to be set for a contested. Are you all?
So,
Do you want to?
I apologize, Judge. I didn't know exactly what the court wanted to do today because this is actually a First Amendment we were just handed today. These are new offenses that happened. I think the offense date is on either Monday or Tuesday of this week. And so I was going to ask the court for a reset at this point because of the new allegations. Additionally, Judge, I was not appointed onto the new cases. So I do not have the discovery as of yet.
So from the allegation that's not the amended motion, but the original motion, the allegation of possession dated from December 3rd, 2025, you don't have discovery on that?
No, Judge, I do have discovery on that. I am the attorney appointed on that case. I would just ask for a reset, Judge, because at this point with the new offenses, I think it would be, for all parties and the court, it might not be efficient to try and proceed with those cases, the MTR today, when potentially we could wrap all the cases together. And I've conferred with the state on this, and that was kind of our approach to it, Judge.
So when is that going to be accomplished, if that is accomplished?
Well, I would need to get on the new cases or get the discovery in the new cases. So as soon as that could be done, Judge.
And are the labs in for the?
So, no, Judge, and the types of charges that the new cases are, we would not be able to proceed on the drug at this time because the turnaround for the testing, but there are 2 other cases that would potentially be able to be proceeding with the.
All right, and the other 2 cases,
It's a theft and a fraud use.
do you have discovery on those?
I do not.
All right, so he needs to have discovery on those. And Norma?
Yes.
This will be the last reset for this case. Set this for a contested hearing in 3 weeks.
Okay.
March 19th? Okay.
Okay. Thank you, Judge.
You're welcome.
Sorry for the confusion.
Oh, no problem. Bashan, Franklin is being reset for March 19th.
Yes, ma'am.
And that will be a contested or a plea of true. I don't know.
Thank you, Judge.
You're welcome. Mr. Bonk, are you ready on your case?
Yes, Judge, we're ready.
And who is your client?
Eric Cepeda.
Thank you. All right, so today we're set for motions and also for discovery. First off, are there any motions? Well, have you all had a chance to confer on motions and see if there's motions that you all can agree to? And if you all can do that, I'm going to ask that you all do that off docket. I think it'll be more
We
efficient.
will.
And then whatever you can't agree on, just let
We'll
the
come
court
back.
know.
Yes, Judge.
All right, and then the other thing, counsel, are there any discovery matters or anything that needs to be exchanged?
Yes, Judge, we have some information we want to exchange with the state. We believe it will be mitigating and very helpful for the state and something we want them to have before they consider their final plea bargain offer. So we'd like to have one more time for final discovery if that setting is possible.
All right, and then state, do you have any objections to any for another discovery setting?
Just for your notes, I know at the last time, the state informed the court that we were still outstanding DNA, but that has recently, like within the last week, been turned over to defense.
Okay. And then counsel, I know you all will want to review the DNA with your
Yes,
client.
please.
All right, so how much time do y'all need? 45?
45? That's 45, 60, whatever.
Oh, see, Charles always throws in the last day. But I will tell you, I was thinking of 60 because that'll give you guys because based upon the discovery settings that we've had and the number of co-defendants, this case is complicated.
This dump got returned over, so I would describe the discovery as the linear stretch.
All right, so then I won't put it as a final discovery, but we're getting close to final discovery, guys.
Yes,
So I will put it for a 60-day reset for you all to get that together and just make sure that you all go over motions too.
we will. Thank you, Judge.
All right, Ms. Ferguson, what date? April 27th. 27th?
That's fine with me.
Okay. Then, State, have you had a chance to review the defense's motion? Are we proceeding on this motion to alter conditions of bond? Or is this something different?
It might be old, Your Honor, or something you've already acted on.
Oh, okay.
Mayor, what's it down there?
Yes.
I think.
The judge, this isn't old. This is from November, or this is Thanksgiving. This was a Thanksgiving deal, so we're good.
All right.
Thank you.
Yeah. No problem. I'm glad you're on it. All right, thanks, guys. All right, and Charles, they say you have someone else on
I
the,
have several more, but the next one is Urabas, Maricela Urabas.
all right. And have you ready to proceed on that?
We are going, yeah, we're going to ask for, the state's asking for a reset, so we're ready to proceed.
All right, could you have your client come up?
Yes, ma'am.
Oh. All right, then it's you, Mr. Bond. No, it's family violence. All right, what is happening on this case with discovery? Or what
There
do they
is
need to
a-
reset?
The state, we reset it last time for the state to talk to a witness. I've been informed they spoke to the witness, but not enough to make a decision. So they'd like a brief amount of time to finish that discussion
All right, 3 weeks?
at the most. I was thinking 2 weeks.
All right, Ms. Ferguson, I need a 2-week reset on your ribis. I'm sorry, Judge. A 2-week reset?
Yeah, I gotta file the motion. The state's talking to her right now. And we're gonna be filing a motion, Judge, to change her no contact to no harmful or injurious. The state is with the complainant right now.
Okay. March 12th.
Okay, March 12th.
Yes,
Okay,
all right, once you sign the reset form, you'll be excused. Thank you.
I'll bring it to you right now.
And Norma, that's for the state to, they're speaking with the complainant, but also for them to tender an offer. Okay. DeAndre Coleman?
Well. I'll get back to you on that. So, is this okay? I don't know. We know who to go over the last one. Yes, sir.
Okay. All right, you want to step back? Need to go over things?
I'm sorry. So you want to talk to me further about signing this, or you want to talk to the judge about the next part of it? I would like to talk to Mrs. Boyd about the next part. Okay.
Okay, talk to me concerning what?
The certification of right of appeal, we're gonna ask for a contested motion to revoke.
Mhm.
My client understands he's gonna plead not true to the allegation, one of the allegations. But it's about signing the trial court certification of right of appeal. I've circled, it's not a plea bargain case. He still does have.
Here's the thing. I would love for attorneys not to check boxes because I decide whether he can appeal or not. And I don't know what I will do in this case. And I don't know if y'all have reached an agreement whether or not he would waive his right to appeal. So I'm in charge of checking boxes. So if y'all could tell attorneys on trial court certification, please do not check boxes because then I have to scratch things out. So now, with regards to the motion to revoke, this is what I'm going to explain to you. This is a contract with the court. If you want a contested hearing, what that means is the state, whatever allegations they're saying that you did or whatever rules they're saying you violated, they'll have to bring in witnesses to prove it. Do you understand?
Yes, sir.
All right. So do you want a contested hearing?
For the harassment allegations, yes, ma'am.
All right. So the only thing that I have in the,
Trespass, apologies.
yeah, the only thing I have in the motion to revoke is an allegation that you committed a criminal trespass and the use of marijuana. Those are the only two things I have.
Yes, ma'am.
Okay.
Excuse me, Ms. Roy, is it possible to only contest one of those?
That can be up to your attorney if that's what you want to do. Yes, you can plead true or not true to whichever allegations you want to plead true to.
Yes, ma'am.
All right. So let me ask you all this.
Yes, sure.
What is the plans for, what is the recommendation?
Recommendation from the states to revoke the law.
All right. And so I only have two allegations, criminal trespass
Well,
and marijuana.
there's gonna be an amended one coming. I need to be in probation because there's gonna be two number ones added to the MTR for the cities.
All right. And in the amended allegations, what are the allegations?
Two charges of harassment.
Okay. So then what we'll need to do is number one, is that going to be filed today?
But I need supervision as soon as I can tell you so they can, on there and get the amended.
All right. So they're telling me that they're going to amend the motion to revoke. So what that means is they're saying they're going to add more allegations other than the criminal trespass and the marijuana. They're telling me they're going to add 2 allegations of harassment. I don't know anything about these allegations. I won't know until somebody presents some evidence to me if they do so. But in regards to motions to revoke, you can plead true or not true to any allegation you want to. So that means you don't have to plead true to everything. You don't have to plead not true to everything. It's really up to you, hopefully after the discussion with your attorney. All right, so what I'm going to do, I'm going to reset it. And I'm going to reset it. It's going to be reset for a contested. If it turns out you've spoken to your attorney and you decide not to contest, your attorney, I'm going to ask that you let probation know because they'll have to have witnesses here. And does everyone want the witnesses in person?
Yes, sir.
All right. So, Ms. Ferguson, can you set this for a contested hearing? And what we'll set it for, we'll set it in 3 weeks. And so that'll give your attorney 10 days, well, more than 10 days.
March 19th.
Yes.
All right, so March 19th is going to be your contested hearing.
Yes, ma'am. Judge Boyd, while I have you, can I ask a question?
Sure. Now, whether I'm allowed to answer that or not depends on what the question is.
If I wasn't informed that further contact would lead to harassment, are those amendments to the?
Okay, so this is what I'm going to tell you. Because you're asking me about the allegations in the motion,
Yes.
I'm not allowed to give you the law on that.
Okay.
You have to speak to your attorney because once I start commenting, because it sounds like you're trying to raise some sort of defense to me. And if no, the question you're actually asking me is sort of a defense. And that's, if I answer your question, I'll be commenting on the evidence and that may make it seem like I'm not being objective and open. So that's a question you'll have to ask your attorney. So any legal questions of that nature, be sure to talk to your attorney about it and he'll give you the law on it, okay? All right, any other questions?
No, thank you, Judge Boyd.
You're welcome. So we'll see you back on March 19th. That'll be a contested hearing. If you discuss things with your attorney and you decide not to have a contested hearing, he'll let probation know so they don't have witnesses.
Love your flowers.
Oh, thank you.
Yes, ma'am.
They brighten the room, I think so. $20. All right, bias. Mr. DeLeon?
Yes.
Hello. All right, so you were not here yesterday, and the reason why I didn't issue a warrant is because I know sometimes that Odyssey has some issues.
What do you mean?
That maybe you didn't receive notice, but you're here now. So now you have notice. You're gonna get a reset form. That reset form is gonna let you know when you need to appear. And you're gonna have to appear on time. This court starts at 9 a.m. You understand?
That's fine.
All right, counsel, where are we on discovery?
Judge, it's the very first setting. I've conferred with the state and I'm looking over discovery right now. It looks like we're gonna have everything, but I need to make sure we have body cam videos, which are gonna be relevant.
All right, Ms. Ferguson, I need a 30-day reset for discovery.
As far as the missed court date, Judge, it was miscommunication.
Yes,
I
Judge,
mean, that's what I sort of said.
big time. Even when I, hold on a second. I mean, even I talked to the bondsman and they were like, what are you talking about? He doesn't have a court date. He has something in March. And it's like, they were confused too, Judge.
Yep. All right, we're gonna come back on March 30th. That's why when it's a first setting, because Odyssey is still doing whatever it's doing, I always have the attorney to reach out because sometimes people don't get notice. But you also want to make sure that your correct address is in the system, because if it is not, it's going to go to whatever address you gave them. So they'll tell you, the clerk will be able to tell you how to check that.
I think I fixed that part when I went to Bell's, was when I went and paid my bond, they were like, is your number still the same? And I'm like, what number do you have? They said the number. I'm like, I don't even remember that.
Well, just check in. Well, one, you need to let your bondsman know that the number is incorrect. And then check in with the clerks and they'll let you know where you need to go to make sure your address is correct in the system.
Yes, ma'am.
All right, you can have a seat. Once you sign the reset form, you're excused. Samuel Tabler or Tabler? Okay, so we're here today for discovery. And how do you pronounce your last name? Tabler, okay. So we're here for discovery. Where are we on discovery?
There's still one thing outstanding, that is the prior ballistic analysis is, still waiting.
Do you have any idea when that will be ready?
Judge, I'm gonna to ask, for the rush.
Okay.
So,
No, I understand it. That's out of your control. Unless you're going into the lab, then.
Some people tell me it's not really that hard. How long does it really take?
Well, whenever the witness testifies and brings the demonstrative, it seems like it doesn't take that long. All right, and that's the only thing that's outstanding?
There's another couple little issues that are outstanding. I don't think they're gonna be in court though. That's the big one.
All right, Ms. Ferguson, if I could get a 60-day reset, and sir, I know 60 days is a long time. Usually I don't do 60-day resets. But if they're able to get the information they need with regards to the ballistics, your attorney will let me know and he'll put you on the docket sooner. All right, what date?
April 27th.
April 27th? All right, we'll be back on April 27th. Do you have any questions about anything?
No.
All right, thank you. Jonathan Pomerantz?
Right.
All right, today is plea deadline date.
We respectfully ask that the case be set for trial.
All right, how long is this trial going to take?
It's discharged, we're proposed to,
A week?
I would imagine.
All right, and I need an acknowledgement of discovery. Ms. Ferguson. Need a jury trial date, family violence. They say a week.
April 28th.
All right, April 28th will be your jury trial date. Counsel, please check with the jail to see if they still have that 72 hours before to have your client dressed.
Okay.
Because, they changed the policy.
When did they change that? I didn't know that.
I have no idea.
Okay.
I just had a defense attorney tell me now, well, no, I think Deputy Lord told me now you have to have the clothing there 72 hours in advance.
Clothing there. Okay, not the letter, the clothing.
Yes.
Okay.
And here's the thing, my understanding, if you have it, sooner, they're not gonna, I mean, later than the 72, not gonna accept it.
Okay.
And if you have it, if you do it 80 hours, I'm sorry, 80 hours in advance, they're not gonna accept it. It has to be,
There's a window.
yes, has to be the 72 hours.
So there's a window and then I wait 4 hours to give them the clothes.
Yes.
Just want to make sure we're on the same page.
Hey, I'm on that page. I don't know if they're on that page.
Okay.
And you may want to talk with Deputy Laura to see if it's changed since then.
Okay.
And you guys are not going to have any motions that I need to hear.
I don't anticipate any at this time. If there are some, I'll ask that we come back within the next 30 days. So that way they're in advance of trial,
All right.
if that's okay with the court.
Yes. All right, we will see you then.
Do I just turn in the discovery acknowledgement to the,
Yes.
okay, all right.
And then I'll sign it.
Okay, thank you,
All
Judge.
right, thank you. Roland De La Garza. All right, so where are we on this?
I think we're at a discovery setting today. We have all the discovery. We're asking for a plea setting. We have an offer from the state.
All right, and sir, how old are you?
52.
All right, Ms. Ferguson, set this in 2 weeks for a plea deadline date, please.
March 12th.
It's my wedding anniversary.
Oh, are you allowed to be out and about on March
I
12th?
think so.
Okay.
We'll
Hey,
be okay.
you know, I'm not gonna cause problems. So what year is that?
15,
Oh, hey, time goes by quickly.
March 12th. Right. Ooh, Judge, I'm on spring break that
Oh,
week.
no, it's spring break.
I can have it 16th.
That work. 16th works.
All right, we'll come back on the 16th.
Thank you, Judge.
But here's the thing. 15 years, but is that the exact date?
Not the 16th, March 12th will be.
The exact date? You know the exact date?
Oh, yeah.
Oh, awesome. All righty, we'll see you then.
Okay, thank you, Judge.
Jacob Liao.
Whenever.
All right, the court is, sorry, no gum chewing.
Oh, it's like, what can I throw that?
Oh, there's a trash can.
We catch that.
Oh, that's okay. All right, court is calling 2025 CR 013-95902, State versus Gilbert Cuellar. Can I have parties announced? Wait a minute.
Thought you called up Liao. I said you called it Jacob.
Oh, why don't I have this? Excuse me, where's Jacob Liao? No, Gilbert Cuellar.
Yeah, I suppose we have to.
Oh, so,
Jacob said today, this is my second setting. You appointed me at the last setting,
Take
Judge.
care of that first. And then, yeah, they handed me this, so I was like, okay. Oh, here we go.
Yes, and I have, the state's already signed off on the agreement that he be allowed to have the fees waived on his GPS monitor, and that he'd be allowed to, if he can show proof of his job, be allowed to go to work, so partial.
Yes, most definitely.
I did check, and I do believe I've received all the discovery, so I will sign an acknowledgement.
All
But
right.
this is my first official appearance.
State, if you will get the acknowledgement of discovery. And State, were you able to tender an offer or no? Okay. And how old are you?
19.
All right, Ms. Ferguson, on this case.
Yes.
If you'll recall this, and counsel, based upon his age, I'm gonna set the plea deadline date for 45 days, because I know sometimes takes younger people longer.
Okay.
All right, Ms. Ferguson. Plea deadline date 45 days.
April 13th.
That sounds good.
All right, once you sign the reset form, you'll be excused.
Thank you, Judge.
You're
I'll be
welcome.
right outside with it.
You're welcome. All right, Gilbert Cuellar. All right, the court is calling 2025 CR 013-959-02, State versus Gilbert Cuellar. Can I have parties announced for the record?
Right, State.
And Jonathan Alvarado for the defense.
And are you Mr. Cuellar?
That's fine.
All right, off the record for a moment. Deputy Laura, can you have them move to the other end? All right, we're back on the record. Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications?
Or not, Judge.
All right, Mr. Cuellar, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Judge be waiving the punishment enhancements, but otherwise proceeding as trial.
Any objections to the waivers?
No objection, Judge. Thank you.
You're welcome. Mr. Cuellar, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with deadly conduct, discharge of a firearm as a third-degree felony. Sorry, just a moment. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason that the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Cuellar, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. This will run concurrent with 2019 CR 5300. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
Judge, you have to take exhibit number 1 and all that.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, just that he's ready to move on with his life. He is on parole for the case that's being run concurrent. And so he's going to go back to TDC and serve his time on both this case and that case, which asks you follow the plea bargain.
All right, the court is finding you guilty. The court will sentence you to 2 years in the prison. Give you credit for any time served. This was to run concurrent with 2019 CR 5300, and there's to be no residing in households with children. Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. Hey, if you don't change your ways, you know you're going to end up spending the rest of your life in prison or jail. You understand? All right, do better, okay? All right, good luck to you.
Thank you, Judge.
Albert Santana. So today is plea deadline date.
Yes, Your Honor, we do have a plea offer. But we wish to remain on docket. I know that it's old and you may put us on the trial docket. We would be ready.
All right, how long is this jury trial gonna last?
A day, 2 days.
All right, Ms. Ferguson, need a jury trial date? You can actually put this on the Wednesday, because they're saying the trial will take a day, so we could do jury selection on a Wednesday morning and then have jury trial that afternoon.
I would just ask not next week, if possible.
Okay.
The 11th. When is spring break?
Yeah, that's spring break.
Like, the 18th would be the next Wednesday.
We can do it on the 18th.
Can we do the 18th, Your Honor?
Sure.
Thank you.
All right, jury trial,
3/18.
March 18th.
Perfect.
All right, thank you.
Thank you, Your Honor. May we be excused after?
Yes, once he signs the reset form and once you all tender me an acknowledgement of discovery.
Yes, ma'am.
All right, thank you.
My
Okay, I'll have a
client's
seat.
agreeing to plead, Your Honor, on a deferred. The only thing is he's on Zoom and he lives in Las Vegas. And if he pleads here, there'll be that issue of him not being able to leave and the transferring and all
If
that.
he's on Zoom and he pleads on Zoom, then he stays there.
Yeah. So I was just wondering if we could reset to plea on Monday. We can send the
Sure.
paper, Quentin Meadows. We can send the paperwork over the weekend and we'll have it all signed and ready to go Monday morning.
All right, that's fine. Mr. Meadows, Quentin Meadows. And what page is he on?
He is like working.
All right, I know all right, I know your client has been on Zoom like all morning. Norma, just recall him for Monday for a disposition.
We'll call him Judge to get him off Zoom.
All right, no
Thank-
problem.
Thank you, Your Honor.
You're welcome.
March 2nd.
Perfect. Thank you so much, Judge.
All right, and don't forget to give Ms. Ferguson his email.
Yes, of course. Do that right now.
All right, Roberto Monreal. All right, on Monreal, the co-defendant was here, and my understanding that there was, the DNA was recently available.
Yes, Judge, that's been recently tendered via e-discovery to defense, but I'll say with the last.
All right, so we're gonna call this back for a final discovery on April 27th.
Yes, sir.
All right, thank you. Once you sign the reset form, you excuse.
Judge, we also we wanted to see if we could finish on his application for the trade school. It was, I believe it was Weston last week.
Judge, Nahara was gonna hear this.
I'm unaware of that, Judge.
All right, so I don't have a specific, oh, what the date written here is on March 3rd.
Yes, ma'am.
All right, do y'all have any documentation from wherever he's supposed to be doing?
I believe he would get the documentation once he does the interview.
Is that the case?
Yes, ma'am. You can go in like from any day, like Monday to Thursday, from 9 a.m. to like 4 p.m. It's like open door.
All right, so here's the thing. I'm inclined to let him apply. But you'll need to give a time
Judge,
for when, because you have 9 a.m. to 1 p.m. Like, why is it 9 a.m. to 1 p.m.?
it's a couple of hours, 2.5 hours for the actual interview process, and then some travel time, lag time before and after to go to it and back home.
So GPS always allow for travel time. So how long, what time is the actual?
They can go at 9
Yeah,
a.m.
we're probably
on the 3rd,
Okay, 9 a.m. to
approximately 3 hours, Judge. Don't know exactly how long it would take.
how
I
long?
wouldn't know either.
Well, is there anyone can call them and find out how long it takes?
It's kind of one of those organic things. It depends on what comes up in the interview, how long the process is. But they believe you show up at 9, there might be a possibility that you don't get in for 15, 20 minutes, whatever it may be, but they seem to feel like 3 hours is sufficient time for, it could be less, but that should be sufficient to complete the interview.
And State, I know you're objecting to him being allowed to interview. All right, so defense, y'all need to give me a formal motion because this is just something that's printed on an updated letter.
I thought there was one e-file, but
I just have this.
if not, we will get you one today.
All right, so that'll need to be done. And I need some specific times. I need you to know who specifically you're gonna meet. It has a location on here, but that really is not telling the court anything. Like, what's the name of the business? So
We
that
have
will need,
independent electrical contractors.
all right, so that needs to be in your motion. And the specific time needs to be in the motion and of course the date.
Yes, sir.
Okay. Anything else?
No, Your Honor. We will get something filed with the court this morning.
All right, thank you.
Thank you. May we be excused?
Yes.
Have to sign this.
Andre Middlebrooks.
Morning, Stephanie, going
Good morning. How are you doing today?
good.
All right, let me see. I don't see it's moving. A little snow.
I'm used to that circle
Yes.
keep floating.
Okay, so I have today as the plea deadline date. Is that correct?
Yes, Your Honor.
All right, so have you all reached an agreement or is this going to be a trial?
We have not, Your Honor.
Okay. How long do y'all expect the trial to last?
Recently, probably with the secretary.
All right. All right, Ms. Ferguson?
Yes, sir.
Okay, from each party, I'm going to need an acknowledgement of discovery.
Yes, sir.
And counsel, you received the psych evaluation results, right?
I did, Your Honor.
All right, Ms. Ferguson, I need a jury trial date,
April 28th.
April 28th.
April 28th.
All right, we'll be back on April 28th. If something clears up and we're able to get you in sooner, your attorney will let you know and we'll have you brought back sooner.
Yes, ma'am. Thank you, Your Honor.
All right,
Have a
you're
blessed
welcome.
day.
Oh, you too.
Yes, ma'am.
Thank you.
Mark Anthony Guerrero. All right, so today is plea deadline date.
Yes, Judge. And we did get an offer that we think would be acceptable, but my client between the last court date and this court date has heard some snippets of information about mental health court, and he would actually be interested in applying to mental health court. We would ask for the court's permission to extend the plea deadline so that he may submit an application for mental health court to see if that may be an option for him.
All right, that application needs to be done today.
Yes, Judge.
And Ms. Ferguson, recall this in 2 weeks for an update on referral to mental health court.
Yeah. March 12th.
All right, March 12th.
Yes, Judge. Thank you very much.
You're welcome. Once you sign the reset form, you'll be excused.
Thank you.
Thank you.
And then, Judge, do you guys have copies of the application?
Ms. Ferguson will take care of it.
Perfect. Thank you very much.
All right, the court is calling 2026 CR 0000978 State versus Jessica Cantu. Could I have parties announced for the record?
David Rodriguez for the defendant.
And are you Ms. Cantu?
Yes, ma'am.
Sorry, Odyssey is being very finicky today.
You have to do an update on it, just.
Yeah. And there are no applications in this case?
There you go.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Cantu, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State proceeding on the indictment as presented?
No, Your Honor, state used to waive the punishment, please.
Any objection?
No objection, Your Honor.
Ms. Cantu, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes. Okay, yes.
All right. And when I say the plea bargain page, that's just the page that tells you what you've agreed to. So do you understand what you've agreed to?
Yes.
All right. According to your plea bargain agreement, the state is waiving the enhancement. They're asking that you be punished to 1 year in the Bexar County Jail under 1244, and there's an $800 fine and no applications. Did you understand that to be your plea?
Yes. Could I ask you for a favor? Is there any way that I can referral to for help?
I'm sorry, what?
A referral from where you go, because they're asking me to take something from the court or from the.
So what will end up happening, when you're at the Bexar County Jail, at the jail, they have different organizations there, and they will do the referral for you for Haven for Hope.
Okay.
I personally can't do that because if I accept this plea, you'll no longer be under my jurisdiction. But I will tell you this, when you're released from jail, if for some reason you don't get to the referral and you can't get there, if I'm still here, you come back here, then I'll be able to pick up the phone, okay?
Okay, yes. Thank you so much.
You're welcome. So everyone is at the plea?
Yes.
Yes.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
That's my first.
State any evidence to support the defendant's plea?
I'm sorry, yes, sir. State up for seats.
Any objection?
No, Judge.
All right, off the record for a moment. Norma, can you call Esperanza Court and see if they have anyone who can come over and give her some resources to help her get into Haven for Hope, or either call the community court? We'll see what we can do today, okay?
Yes, thank you.
Thank you, Judge.
All right, State, you may be excused. Did you review the waiver and consent to stipulation of testimony with your attorney? Did you understand it and
Yes.
sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Only that we urge the court to follow our plea bargaining agreement.
All right, the court will follow your agreement. The court will sentence you to 1 year in the Bexar County Jail under 1244, give you credit for any time served. There's an $800 fine. Time and money will run concurrently. Now, with regards to the 1 year in the Bexar County Jail, I'm not in charge of whether the jail counts every day that you spend at the jail, 2 days for every 1 day spent. That's completely up to them. The only thing you're receiving from me is a sentence of 1 year in the Bexar County Jail. So you will not spend longer than a year. You should not, okay? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Okay, so deputies, if you could let her remain in the courtroom, I'm gonna see if I can get someone to come over from the treatment courts to help her out. All right, thank you. Joseph Dominguez.
Morning or afternoon now.
All right, so here's the thing. Court in here starts at 9 a.m. You've been here before.
Yes, I was late today, so I'm sorry.
It's not
I
allowed.
hard drove this one.
Okay. All right, so today is plea deadline date.
Yes, Your Honor, we tried, but we're at an impasse. We're gonna need to try this case, Judge.
All right, how long do y'all expect this trial to last?
3 days with jury selection, 3 days.
All right, and I'm gonna need an acknowledgement of discovery, and Ms. Ferguson. Thank you.
Oh, yeah, I got it.
I need a jury trial date, 3 days.
I can do. I can do, May 12th.
That
All
should
right.
work.
Your jury trial is gonna be May 12th. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Do you understand?
Yes, sir.
All right, just have a seat. They'll give you the reset form.
Like I said, sorry about being late this morning. I had hard trouble.
All right, thank you.
Have a seat, buddy. You're good.
Adam Cruz,
He's present, Judge. He's in the box. I conferred with
come
the
up,
state.
please, Mr. Cruz. Yes, counsel.
So they've made us an offer today.
Mhm.
My client wants to think about it and we want to go over all the discovery, which I've now gotten.
All right, sir, how old are you?
37 years old.
All right, Norma, recall this for 2 weeks for a plea deadline date? Do you have vacation or something?
I do, but I'll be back in 2 weeks.
Okay, what date, Ms. Ferguson?
That would be at March 12th.
March 12th? All right, so we'll be back on March 12th, and that'll be your plea deadline date.
Tomorrow today.
Hello, Mr. Braggs. Oh, I'm doing okay. All right, the court is calling 2024 CR 1544, State versus Francel Braggs. Could I have the parties announced?
Opinion for the state of Texas.
Good afternoon, Judge Alfonso Cabañas from Mr. Braggs, who's present.
And are you Mr. Braggs?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision and State's Motion to Supplement pending motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Francel Braggs who was placed on community supervision in 2024 CR 1544 for the offense of possession of controlled substance penalty group 1, less than 1 gram, on June 11, 2024 for a term of 5 years? Is that you?
Yes, ma'am.
State?
Your Honor, off the state's original motion to revoke violation number 1.
Any objection to the waivers?
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 1, the court could, just 1 second. All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 1?
Yes.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, that is to grant the state's motion, revoke the defendant's community supervision, and sentence the defendant to 2 years state jail.
Off the record for a moment. All right. And we'll make sure the judgment is corrected.
Yes, Your Honor.
All right, the court is going to grant the motion and revoke. Are you asking the court to follow the agreement that's been reached between you and the state?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court then will revoke, sentence you to 2 years in the prison, give you credit for any time served. And the court will recommend the therapeutic community because I see that's what the court had recommended as a part of his conditions, that he do some type of sober support. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Because this is because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. I'm requesting the therapeutic community. I do not have the authority to have them place you in that program. You will need to ask them to place you in the program as well, but the judgment will show that that's a recommendation for the court. Do you understand? All right, good luck to you.
Okay, thank you. Yeah, one.
All right, you too.
Copy of dismissal.
All right, Pierce Pearson, what are the results from VTC?
My client has been denied from BTC once again. We did submit a supplemental letter outlining the connection that my client has, mental health has with his service. We also submitted medical documentation and a letter from a board certified psychiatrist that works with Veterans Affairs. But it's my understanding that the state, as the gatekeeper, will not allow him into the program. And at this time, I don't know that it would be in my client's best interest. They've shown that they do not want him in that program.
Which I do not understand, because when reading the code, it appears to the court that he should be in that program. So I don't know what they're basing it upon.
At this time, you did mention that there would be other avenues perhaps that we could explore. The mental health court
Yes.
does seem to be a potential avenue for him. And at this time, we'd request judicial notice of the documentation we've submitted to Veterans Court and allow him to be referred to that court and or accepted if you have the ability to do so today.
Well, I can't do it today because, again, the state has veto power with regards to that. But what I will do is I'll have him referred to the mental health court.
Okay.
And we'll see what happens. I still don't understand why he's not being accepted into Veterans Treatment Court. We're supposed to be here for our veterans, and then it appears that we are not here for our veterans.
I agree, Your Honor.
All right, so what I'm going to do is I'm going to reset this, and I'll reset it for, state if you have no objections. All right, so I'm going to reset this for 3 weeks, and we'll do the referral to mental health court.
Thank you, Judge.
All right, once you sign the reset form, you'll be excused. We're going to see I think everybody wants you to get the treatment that you want. So we're going to keep working and make sure that happens. You're welcome.
March 19th.
All right, March 19th. And if we're able to get you in mental health court before then, your attorney will know. All right, thank you.
Thank you. Appreciate it, Judge.
You're welcome. All right, so in this one, we just need a jury trial date, correct?
That's correct, Judge.
All right, how long do y'all expect the trial to last?
4 or 5 days.
All right, Norm, I need a trial date, family violence, 4 to 5 days.
April 28th.
April 28th.
Yes, Your Honor.
All right, your jury trial date will be April 28th. All right, thank you. Jonathan Rodriguez.
Judge, I think he's the one who was via Zoom.
All right, let me see. I don't have him on Zoom.
Okay.
But I have down that he was supposed to be by Zoom. I think he was here this morning.
Yes, Your Honor.
All right. So what is happening with that case?
Judge, I think there is a plea offer at the last court setting. I spoke to my client.
Mhm.
I think we should just keep it on the trial docket.
Okay. All right, Ms. Ferguson, I need a jury trial date. How long do you expect this to last, counsel?
I'm sorry.
Jury trial date. How long do you expect this to last?
No more than 3 days, Your Honor.
3 days. And it's criminal trial division.
You can do that one on May 5th.
May 5th, counsel?
Yes, Your Honor.
All right, so that will be the jury trial date for that, and you'll let your client know? All
Yes, Your Honor.
right, thank you.
Okay.
Julian Tejo?
He's present, Judge.
All right, if you'll come forward, I have the page number. It's on 4. Hello. All right, on this case, where are we on discovery?
Judge, I believe I have everything that the state has tendered. They also tendered a plea agreement. My client and I discussed it, and he wants some time to think about it.
Mhm.
So we're asking for one more, I guess, pre-trial.
All right, sir, how old are you?
34.
All right, Norm, if you can set this for 3 weeks for a plea deadline date?
The 19th, March 19th.
March 19th, counsel?
Yes, Your Honor.
All right, we'll see you back on March 19th. At that time, you'll need to let the court know whether or not you've reached an agreement with the state. If you have not, your next court date will be a jury trial date.
Okay, thank you so much.
All right, thank you. All right, thank you. All right, the court is calling 2025 CR 015168, State versus Rosalind Torres. Can I have parties announced?
Ready for the state?
Jose Rocha from Torres, ready, Your Honor.
And are you Ms. Torres?
Yes, ma'am.
All right, Ms. Torres, you have a right to appear in person. Did you review the document entitled Defendant's Consent to Plea by Video Conference with your attorney? Did you understand it?
Yes.
And did you electronically sign it?
Yes, ma'am.
And Attorney Rocha, did you electronically sign it as well?
Yes, I did, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video conference. Ms. Torres, did you review the application for deferred adjudication with your attorney? Did you understand it and electronically sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Ms. Torres, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with fraudulent use of possession of identifying information less than 5 items as a state jail felony?
Yes.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or is the state will silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
You broke out. I'm sorry.
Did you intend to give up those rights and enter?
Oh, yes, ma'am.
Did you understand that the court grants your application for deferred adjudication if for any reason your deferred adjudication is revoked? The court can find you guilty and sentence you up to 2 years in the state jail facility?
Yes, ma'am.
Counsel, has your client been able to provide any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do believe so.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Torres, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at $1,000 fine probated. State recommends deferred adjudication. They're taking in consideration 2025 PF 36626, 2025 AL 012439, and there's to be restitution payable in the instant case to the complainants. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State?
It is the plea, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be 100 hours of community service restitution. There's to be no contact with Alexis Smith, the felony theft course in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge, you have to take exhibit number 1 and all attachments.
No objections, Your Honor.
All right, did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented stipulation of testimony and stipulations Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, please.
All right, so the first question I have with regards to restitution, from reading through it, it appears that the check wasn't, no funds were given in exchange for the check.
I thought I read that they were.
I could be reading it incorrectly, but what it says is, let me see. They placed there was a stop payment on the check. Because it said attempted to cash a fraudulent check. All right, I see where it says, counsel, in the notes, I see where it says, not in the notes, but in the police report, it says that it had been cashed at one of their locations. And then the company, once they gave funds to your client, then that company sent the check to the bank. And then the bank said, stop payment for it. So the people who are owed the money is the PLS, check cashers of checks. Okay.
PLS or PSL?
PLS, Check Cashers of Texas, Inc. And I'm just trying to find the specific amount.
I believe the amount of the check was 1509 and 59 cents.
Okay, you say 1509.
1509 and 59 cents.
All right, counsel, are you in agreement that the restitution that's owed is $1,509.59?
Yes, Your Honor, that was our understanding. We were, when we were discussing this matter, because of the controversy that we're discussing right now, it was the understanding of the district attorney's office that the restitution amount was to be determined after today. However, yes, that we do agree with that amount.
All right, so just give me a moment. This is what the court will do. The court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment. When are you due?
In about, it's supposed to be March 31st, but I'm already dieted, so it's like it's a gamble.
All right, so it's going to be proof of employment within 90 days of medical release.
Okay. And then I have a question. I do work for home care providing, so I don't know,
I
is
don't
that
allow,
gonna reflect on my work? Because that's the only job that is helpful that's the only job that works with me. I have 7 kids. I'm about to have 8, so that's the only one that is more compatible with my hourly and stuff on picking them up. Like, that's the only boss that I can find that's understanding.
well, this is what I can tell you. I don't allow people in my court to work as home health care provider. The only exception I will even give to allow that is if there is a letter from the employer that states that they know what you're charged with, and whomever you're caring for, they have to provide a letter saying that they know what you're charged with.
Okay.
So there's the restitution to PLS, Check Cashers of Texas, Inc. And the amount of $1,509.59. Take into consideration 2025 PF 36626, 2025 AL 012439, 100 hours of community service restitution, Okay, so 100 hours community service restitution. I'm already parenting. Once that's completed, the community service hours will be deemed satisfied. There's to be no contact with Alexis, Alexis Smith. And I'll order the. All right, does she need the felony theft course?
Judge, one of the cases being TIC is theft.
All right, felony theft course. Field visits 1 time per month for 6 months. Probation, is there anything else?
I received 2 different names for the restitution. Can you just verify who the restitution is going to, please?
It is P as in Paul, L as in Lane, S as in Stephanie, check, Cashers of Texas, INC.
Thank you.
Thank you.
Nothing else, Judge.
Is there anything else you need from the court in order to be successful? Do you need anything else from the court?
Your Honor, just for clarification purposes, will the 90 days also apply for all the other requirements for probation after she's been discharged? I just don't want to make sure that she's not set up to fail.
Oh, what she'll need to do, she'll need to provide a medical documentation from probation if she's not able to do this. And I will tell you, in this court, probation is understanding. They know she's about to give birth. And if there's an issue, counsel, you can come in and discuss it with the court.
Thank you very much, Your Honor. I just wanted to make sure that she understood that and we were clear on that end.
And then Vashon, she's only allowed to work with home health care, and I'll only consider it if she provides documentation from her employer that they are aware of this charge, and for whomever she's providing the services to. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand and electronically sign it?
Yes, ma'am.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right, in this court, communication is key when you're on probation. Let probation know if there's an issue.
Okay, thank you. I appreciate it.
You're welcome. I'm going to send you and your attorney to breakout room number 2. Probation will come in that room and speak with you.
Okay, thank you.